तो स्वागत है आप सभी का वंस अगेन है टू द यूट्यूब की ऑफिशियल अपडेट में। काफ़ी इम्पोर्टेंट अपडेट है इन रिलेशन टू द बैंक पेंशनर्स के रिलेशन में। सो वी विल सी दैट हेयर। सो दैट हैज़ बीन रिटन इन रिलेशन टू द 100% DA न्यूट्रलाइजेशन, जो कि ऑलमोस्ट सभी बैंक पेंशनर्स का होना चाहिए। सो पेमेंट ऑफ 100% DA न्यूट्रलाइजेशन ऑन फुल basic pension. So I most humbly submit the following for your kind information and for doing the needful in the matter at the earliest. So I retired from Union Bank of India, Penpally Nagar branch as manager with employee number this on 2001 after serving the bank for 29 years, and I'm in receipt of pension from 2009, and I'm a pre-November 2002 retiree of the bank. So while paying pension from 27th November 2009, the bank did not pay 100% DR neutralization to pre-November 2002 retiree, which it paid to the post-November 2002 retirees for the period up to 30th September 23. So this was a collusive discrimination against pre-November 2002 retiree, including me. So the pre-November 2002 retiree and post-November 2002 retirees being similar subjects to pension regulations, the non-payment of 100% neutralization to the pre-November 2002 retirees and its payment to the post-November 2002 retirees is violative of Article 14 of the Constitution of India, which a bank which is state or the government can commit. So the government, that is the Ministry of Finance, Department of Financial Services, while sanctioning the payment via its letter number dated 5th of October 23 to the Indian Bank Association, sanctioned the 100% DR neutralization effective from 1st of October 2023 by stipulating that no arrear shall be payable for the period falling before the effective date, so thus depriving to each pre-November 2002 pensioner the arrear of DRNS relief for 221 months from 1st of May 2005 to 30th of September 23. So while sanctioning the 100% DR from 1st October 23, the Department of Financial Services was trampling upon the law laid down by the Constitution bench of the Honorable Supreme Court in D.S. Nagara versus Union of India on 17th of December 1972, where it was held that the payment of pension is not subject to the direction of the government and that it is governed by the rules. So the above part, the Banking Companies Acquisition and Transfer of Undertaking Act 1970, where section 19 of it confers on. So friends, you can see the government only powers to give previous sanction to the regulations, so neither the act nor the pension regulations empower the DFS to interfere in a day-to-day administration of pension regulation. So as such, it is strange that the DFS has chosen to sanction the DR through its letter dated 5th October 23 in a perverted manner. So the above apart, the second of you is a body corporate having autonomy of operation in matters including HR, which shall not act in violation of pension regulation. So its board has put in place. So I had brought the matter to the notice of second of you by my letter number dated 24th November 23 and of the first of you were letter number dated 25th November 23, pointing out the various illegalities involved in it, and none of you have uttered a single word against what I wrote to you. So, testing to the legitimacy of what I wrote, in spite of lapse of about an year, it may kindly be noted that the bank, which has to act with integrity in each and every transaction, was acting without any trace of integrity, and the government that has to safeguard the property of subject and ensure their welfare was conducting a daylight robbery of their property. So both were outdoing the chain snatchers and housebreakers who attack only unknown people by conducting a robbery of the property of the people who worked ardently and arduously for them all alone while in service. So it is also pertinent that the dearness relief sought to be paid is out of pension fund created out of CPF of employees and families of deceased employees held in trust for payment of pension and family pension, and not out of the revenue amount of the bank or brought out of the exchequer of the government. सो ये यहाँ पे इम्पोर्टेंट है भी जो पेंशन है फैमिली पेंशन है वो किसी भी रेवेन्यू अकाउंट से नहीं जा रही है, वो हमारे खुद के ही हार्ड अर्न पेंशन फंड है. So as the DFS was sanctioning the 100% DR neutralization to the pre-November 2002 retirees from 1st October 23 in a corrupt way by exercising a discretion which it does not have, so I request the first of you to revisit the sanction by directing payment of arrear from 27th November 2009 to 30th September 2023, or else to state reason as to why I shall not approach a competent court to set aside its sanction dated 5th October 23, and also for restaining the DFS from its invasion into the day-to-day administration of pension regulations, which is de jure and de facto unauthorized at your cost, risk, and responsibility. The second of you is hereby requested to kindly pay me the arrears of DR from 2005 to 23 as was paid to post November 2002 retirees, along with interest at 9% simple, in compliance with the pension regulations in force in letter and spirit, to do away with the discrimination against me. So in case either of you is in disagreement with any aforesaid, I may be informed within a fortnight, means 15 days, dated this 6th of January 25, Mr. CNV. So Mr. CNB sir की तरफ से a letter to DFS and UBI in regard to 100% DA neutralization and the arrears payment. So that's all.